Hey, Andrew, can you tell me some more about attorney fees and property damage claims?
Sure, Krista. It's particularly important for those people who live in Florida, and I want to really direct my comments today to people who live in Florida and have property insurance in Florida, because in this past year we've had two major hurricanes affect the west coast of Florida, and people have been making property damage claims, trying to recoup what their losses are through their insurance companies. And there have been some changes that have occurred in the last few years that have really been to the detriment of the public. And I wanted to get into that for a while, and hopefully people will understand what it is that the Florida legislature has done and how seriously they've been affected and hurt by it. So let me start by saying, when you have property insurance and you make a claim against your insurance company, prior to just a couple of years ago, Florida allowed people who make claims against their insurance companies to recover their attorney's fees in that lawsuit if they're successful. And that is no longer the case. Now, in this country, we follow what's called the American rule, which makes some sense since it's America, and not the English rule. And the English rule is that the loser pays the winner's attorney's fees. In the United States, or in America, we follow the American rule, which says that you don't pay attorney's fees if you're the loser or the winner, unless you have a written contract that specifies that you're entitled to attorney's fees in the event that you succeed, or there's a specific statute that allows you to recover attorney's fees upon success. Now, the insurance industry in Florida, which is obviously a very strong lobby, successfully changed what we always thought of is what we call one-way attorney's fees, meaning that when you sue your insurance company, if you're successful, you're entitled to your attorney's fees. That is no longer the case with these property damage claims. And so how does that affect you? Well, let's say that your house is seriously damaged by a hurricane and you bring a property damage claim. Your property insurer comes in, they look at it, and they lowball you, and they don't give you enough money to repair your house. That's actually been the subject of some news reports of late, and currently a class action that's been filed where a particular property insurance company has been caught changing the records that and the adjuster's recommendations for what claims should be paid. But that's really beside the point. If you're unhappy with what's been offered in settlement of your property damage claim, your alternative is really to go to court. Now, when you go to court, obviously you need an attorney. Now, your attorney is going to expect to be paid either on an hourly basis, which most people can't afford a top drawer attorney on an hourly basis, or you can pay them on a contingent fee basis, meaning that the attorney will get a percentage of the recovery. Now, before this change in the statute, if you sued your insurance company, you'd be able to get an attorney, and that attorney might not ask you for money up front. That attorney knew that if they're successful with the claim, that they would be able to recover attorney's fees from the insurance carrier. Now, the property insurance carrier, whether it's a big claim or small claim, would have to pay those attorney's fees. If it's a small claim, then a contingent fee would not work because it would not be economically feasible to pay your lawyer a percentage of that, because your lawyer is probably not going to take the case because there's not going to be enough money in it for them to justify the time and the risk that's involved. Now, if it's a large case, then if you have a contingent fee arrangement with your attorney, the attorney will take a percentage of that recovery as their fee. Now, what's the problem with that? Well, if you get 100% of your damages, of your property damage, and you have to give your attorney a third or 40%, that means that your actual recovery is down around 60%. So you're out of pocket for 40%. Just to take a round number, let's say that your losses are $100,000. If you've got to pay your attorney a contingent fee, then the attorney may take $40,000 as their fee, and you would be getting $60,000, which means that you're $40,000 short of what the actual cost is of making you whole. Now, there are some statutes that are available to allow you to get attorney's fees, but those really don't make you whole, because if you're going to get attorney's fees, then you have to make an offer that is not going to be the full amount that you're going to be recovering. So getting back to my original point, which is to change in the statute. Before, if the attorney brought the case and was successful, the insurance company would have to pay your attorney as opposed to you paying your attorney. Now, how does that affect you? Well, number one, if you've got a small claim, as I mentioned a moment ago, you can't find an attorney to take that case. And if you want to pay them out of pocket, then it's not going to be economically feasible or make any economic sense to pursue that small claim. If it's a large claim and you are giving up a third or 40% of your claim to pay your lawyer on a contingent fee basis, you're not being made whole. And so the end result is that you don't get what you've paid for. You've paid for insurance, but you're not getting fully covered for what your losses are. And that's the impact of the statute that was amended a few years ago, that takes away your ability to get attorney's fees, or what we call one-way attorney's fees, when you successfully sue your insurance company. Now, we pay a ton of money for property insurance in Florida. It's a requirement if you have a mortgage, and it's very expensive. And if you're going to pay all that money that you're mandated to pay for property insurance, you should be getting what you're paying for. Meaning that if you have damage and your insurance company doesn't want to make you whole and pay the full amount, then you have to take them to court. And if you take them to court, you should be made whole, meaning that you should get the full amount of your property damage, plus you should get your attorney's fees from the insurance company that has declined to pay you the fair value of what your loss is. So what do we do about this? The only thing you can really do about it is to complain to your representative, whether it's your state house representative or whether it's your state senator, and make it clear that this is unfair, that this is wrong, and to insist that they put one-way attorney's fees back into our statute so that people who are damaged by these property damage claims can in fact be made whole. And as we have more storms that seem to be affecting Florida with a greater likelihood and with increasing intensity, these claims are going to continue to grow. So it's important that you make sure that your legislators know that they have to make changes and put this right back into the statutes so that your attorney's fees get paid by the insurance company when you successfully challenge their lowball offer. So hopefully that's helpful, and hopefully it'll make some change in the future.